Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we embark on a special series on the issue of arbitration in India. We all know that investments in India's economy, in manufacturing, in business, in oil and gas exploration, all hinges upon the availability of the option of the alternative dispute resolution to the investors. Arun Kumar Singh, who is chairman of ONGC, recently in an arbitration conference made some very important points on the issue of arbitration. So we have titled the show as Learning from International Practices, Time is of the Essence in Arbitration. And the points, of course, our panelists will discuss based on what the ONGC chairman has opined. I would like to welcome Justice Arun Kumar Singh on the show. Sir, thank you so much for your time. As an introduction for all you viewers, sir is a leading arbitrator in India, also practices in Singapore where he is a sitting judge at the Singapore International Commercial Court. Earlier, he has served as the judge of the Supreme Court of India, also as the Chief Justice of the Delhi High Court and the Punjab and Haryana High Court, but best known today as one of India's busiest arbitrators. Thank you so much for your time, sir. We have with us Mahesh Agarwal, who is managing partner of India's leading litigating law firm at the Supreme Court, which is Agarwal Law Associates. And he is somebody with very strong views on the subject of alternative dispute resolution. Good to see you, Mr. Agarwal, and thank you so much for your time. We have with us Ruby Singh Ahuja. She is senior partner at Karanjawala and Company, one of India's leading litigating law firms at the Supreme Court. And she herself has spent a lifetime in litigation and ADR, and somebody who has distinct views on this subject. Good to see you, ma'am. Thank you so much for your time. At the outset, let me sort of read out the first paragraph of what Mr. Arun Kumar Singh said, and then we'll go to our panelists for their opinions. Arun Kumar Singh, who's the chairman of ONGC, made these points. He said many times public sector undertakings are told that they are frivolous litigants. He also says that excessive conservatism of PSUs is also the reason for disputes, and to save their own skin, they want to arbitrate and not take decisions. He also alleged that excessive optimism of vendors also is the cause of disputes because they bid very low, and sometimes the bids are bordering on insanity. He says he himself can't believe how low these people are bidding. And he also said that in 30% of the matters, problems are coming up because the contract itself doesn't have many provisions for resolving disputes. It leads to a dispute that can then only be resolved through arbitration. So I want your opinions on what he said.
You see, I think it's really at the outset, I must congratulate you for opening the debate on this very vital topic, which India is struggling to find answers. And as you have said, that the title is International Practices on the one hand, and the time is the essence. So both the things are very, very important, to which we may come later. But first, to answer your question, you see, this question has 3 or 4 components, if I may say so. Initially is there's the remarks of Mr. Arun Singh that the conservative approach of PSUs on the one hand, and very I would say a bold approach of the contractors while bagging the contract. And this is 100% correct comment, if I may initially say. I tell you from my example, my experience. When I was a lawyer, I have at least worked for 12 to 15 public sector undertakings. Okay. And I was doing lot of arbitrations so that I know the psyche, I know the mindset of public sector on the one hand. As judge, I saw it from both sides, and even as a practitioner, I was doing the work for private sector as well. And now as an arbitrator, of course, as judge or arbitrator, you have to be really, totally objective. You have to decide as per what are the papers before you and what law says and where the justice is, without being influenced by what is the psyche of these people. But these are the issues which Mr. Arun Singh has raised. They contribute to unnecessary litigation in the arbitration, and there I say that he is right. Now, I give you one example, and which from my experience, I said that which I have observed. Suppose in a particular contract, that dispute has arisen and the contractor has claims. He says that, okay, I mean, it may have arisen because of various circumstances, but let us see that the contractor says that I have these monetary claims. And I give you, say that these claims are for 100 rupees, I'm saying. And the public sector, when they scrutinize in the department, they may say that 40 or 50 or 60 rupees is a legitimate also claim which he should be given. So they want to give. But as Mr. Arun Singh said, they are not in a position to give such a decision. And many times, if that 50 or 60 rupees is given, the contractor may also accept that. And it may not go for litigation at all. But for various reasons, even if the money is legitimately due and the particular officer doesn't want to be in dock tomorrow, that tomorrow the CVC will be against me, and then these accounts people will be against me and all that. So I should not put myself in a risk. So let it be decided by arbitration or by the court, and then whatever happens. Now that is one thing. But then when it goes to ultimately arbitration, instead of those 100 rupees I said,
yes,
he will raise a claim for 500 rupees. So 5 times claims. Fraudulently and all that. So they say, okay, if I raise 500, at least I'll end up getting 100, 200, 300 and all that. And maybe ultimately the result may be that he is able to get something more than at which he bargained.
Okay.
And particularly in the form of interest, etc., which has mounted. Now, another thing which Mr. Arun Singh said is also equally, and I have seen from myself, I remember today now award is given, so I can quote that as an example, although these proceedings are under 42A confidential. But again, I am saying one public sector, I am not naming the public sector because of confidentiality. And the claim was filed by the contractor, and we could see the contract was taken in that case by underpricing. The quoting, which was really, I mean, which should have been, say it was, okay, I can only give this much hint for this collection of toll, etc. And you can understand now which public sector it is. But then, without realizing on doing, not that the contractor would not have done that particular exercise or due diligence,
yes,
as to how much vehicles are passing through, how much toll they will be able to collect. Still, the bid which he gives, that I will, out of this, I mean this X amount which I will give to that public sector, were far more than what was the collection. Okay. So that maybe, yes, there Mr. Arun Singh said that the intention is to ultimately capitalize on that. But this is one kind of example I am giving. This happens in construction projects, etc. also. So they take at a low rate and to say that we should be L1, we will be granted this, and ultimately from day one they will start building the case for arbitration. Okay, if I have contract price is much less than what it should be, even the reasonable, and it would be even my cost would be high, so I'll recover it in the arbitration by making the claims. So we'll start doing that exercise. So this psyche of the contractors also has to be nipped. There's no doubt about it, and that is why many times there is no court fee. So even as I gave you example, 100 to 500, so they will have their claims which are far higher than what it should genuinely be under this. So therefore, it is these observations are correct, but what is needed insofar as public sector is concerned, those officers out of fear they don't do it. So there should be some mechanism. There are ways to do it, and some steps are taken also, which it is not possible to discuss here in detail. But some mechanism should be adopted where those who are honest officers, and they want to settle the dispute, they want to save the money of public sector, they should be protected as well if they take such. So that should be put in place. And insofar as these contractors who quote the rates which are much below than even the actual rates which should be, then you see in award of tenders, and as when these sometimes a tender is awarded in favor of X, So why is precluded, and why comes to the court and says that, look, I was L1 and still it is awarded to the other party. So courts have upheld such kind of, under sitting in 226 High Court, suppose it is challenged, the courts have upheld such kind of awards also on the ground, then precisely on the ground that you may be L1 but your court rates were unrealistic. And therefore, if the committee after scrutinizing has come to the conclusion these were unrealistic, so it should not. So therefore, PSUs have to again in such cases take when such rates are quoted and these kinds of contractors who are coming and with this purpose, at that stage the exercise is needed, more vigilance is required, that look, if these are unrealistic we are not going to award to it even when it is L1. And again, courage is needed, because tomorrow may not be inquiry, you did not give it to the person who are the lowest, you gave it to the. So those are some of the ticklish issues which are to be resolved, but the observations were
correct. Thank you so much, sir, for your opening comment. I'll now go to Mr. Mahesh Agarwal. Mr. Agarwal, you are sort of seen every day in the Supreme Court in some of the most high profile cases, some of them being challenged to arbitral appeals. You also do arbitrations, but you have gone through the whole process where the awards are challenged right up to the Supreme Court many times, some going in curative also. So you have seen how this system functions very closely. What would you make of the comments made by Arun Kumar Singh, chairman of ONGC?
The most important statement he made is timeliness. So that starts from the execution of the contract. His first comment was that can we have clauses in the contract which kind of mitigate against delays, etc. There the private parties have no role because most of them are tendered contracts. And in tenders there are standard form contracts where there is no negotiation. So there is no negotiated contract. These are one-sided contracts given by NHI, etc. Now most of these contracts have provisions of mediation prior to arbitration.
Okay.
Now if mediation is resorted to effectively, then a lot of issues can be solved. Number one issue that can be solved is that the person who's the officer doesn't have to take a decision to pay or not to pay. Let us assume genuinely he's in two views, whether to pay or not to pay, he's not very sure and he doesn't want to take a chance. Mediation is a route which can be adopted immediately.
Yes.
Before going for arbitration. So a lot of things can be sorted at that time. Second is to minimize the time. It is not necessary in most contracts that to wait for conclusion of the contract and initiate arbitration. There are several things which happen during the performance of the contract, that while the performance is going on, for small issues you can initiate mediation and close the issues as you go by, which helps you in preserving evidence. Your people who are performing the contract, the evidence is there, the witnesses are there. Otherwise what happens, the contract goes on to 5 years. 3 years after that the arbitration is launched. In 8 years half the evidence is lost. So the objective should be that if there are certain issues which are arising during the performance of the contract, they should be resolved while going forward. That way even the authority will be in a safe position that they will not be mulcted with a 5 times award or claim after the conclusion, because the party is bound to be reasonable during the performance. It may become unreasonable later on. Yes. So these are many methods by which it can be resolved during the ongoing of the arbitration.
And on those 2 points of excessive conservatism and excessive optimism, PSUs being
on that mostly what I have seen is mostly the PSUs have an assessment of an average value of the awarded amount. So for example, like in a toll case, the authority would know that ordinarily the toll should be in the range of 1 to 3. So if somebody bids lower, they have the authority to reject, and it should be rejected on that ground, not merely because it's L1, but they have all estimates. They have comparative contracts. There is enough data available. So whether a bid is unrealistic or not, mostly the authorities know. But having said that, there have been cases that parties have given unrealistic bids just to get the contract or to get eligibility for the future and then litigate
later on. We'll come to that in the next question.
One minute only, I may not forget, I just wanted to. First, I forgot in that case which I was telling, that where it was, bid was like this, we gave an award of 150 crores in favor of PSU in that case.
Okay.
After knowing that. Second thing about the mediation, very apt comment made, but there is one caveat I would say, is this: mediation is where both the parties agree.
Yes.
Correct. Now I have seen, my again personal experience, many times during mediation the the officers from that PSU or the government who are appearing, and they find that a particular sum which should be given is reasonable, but they are not able to give their consent. And mediation sometimes fails. Mr. Arun Singh has made the comments, and all other public sectors and their CEOs or chairperson should try to actually set this right also. And I am again, from my experience, as I said, this was where the two parties came before me, before going to the court, before going to arbitration. They agreed that they will appoint me as mediator. One public sector undertaking, Navratna, and other very, very big company, which is the contractor. And I got it settled. Both the parties, they also agreed. Now, the public sector says that we want to have the approval of the board of directors. Okay. Now, what happens, maybe I hope that it was exception only and it is not a rule. Board of directors ultimately said that whether this, that we had to indicate at what it should be settled, and the public sector was recipient of the amount, the contractor were paying in that, because some claims were of the public sector, and the the amount at which we were settled. So they now take opinion of another Supreme Court judge.
Okay.
And interestingly, that Supreme Court judge also gives an opinion, yet it's a very fair settlement in your favor. In spite of that, board did not agree, and the settlement failed, and the matter went for arbitration.
This is excessive conservatism.
Yes.
Exact. I mean, this is the example.
I wanted to give. I may not forget when.
But thank you for highlighting.
Mr. Agarwal was stating that. Let me share this example.
Yeah. So you're right. There has to be a trust factor also. Yeah. The mediator has recommended something. Yes. Your own people are accepting the recommendation. Yes. There is an independent judge outside the mediation system who is also recommended. Right. But if you trust nobody, then obviously the leakage will go on.
There is no protection to the government person even after retirement. So what happens that, the courts will also have to somewhere stop opening these cases, because if you're going to open a case after 5 years when everybody has retired and now they don't even have the government support to protect that decision, so then he will say, boss, why should I take it upon my head? Let it go into litigation. That's the problem. Now, it's a very fine line you have to draw. With the problem, India has certain problems of transparency. Really? Now, see, the thing is that you want to keep it, he said that the contracts are very rigid. They don't give a leeway to the person. The problem is that somewhere in our mindset, both ways, private as well as public, we want to deviate from the contract. The answer is not to keep flexibility in the contract, because that will lead to, everybody taking their own decision. The answer lies that, we have to go back and learn to follow contracts. If the contracts are followed, this rigidity and all will not rise.
And about those 2 points of excessive conservatism and excessive optimism, what do you feel about excessive conservatism of the PSUs and excessive optimism?
See, I don't blame, there is no conservatism. I think it's a protection. They have to protect themselves. As sir rightly said, he's an officer, he's going to retire after 4 years, or he's going to put a signature, okay, if 60 crore is due, I think 45 crore mediator has said it's a fair, because you will keep on litigating. But the thing is, after 3 years, if somebody is going to open and file a CBI, whistleblowers, don't forget, India is now full of whistles. So this where we have to find loopholes at various ends. It's not only the arbitration route, which is that they are time-consuming process, and that's why government, PSUs don't want to go before arbitrations. There are other issues also. If those are solved, I think mediation you can live with mediation.
Mediation is the best thing.
Yes.
If these things are taken care
of. If these things you have to take care, these loopholes have to be tightened, and you have to give some protection to that officer, according to me, even after retirement. What happens that I have seen people coming to office that he has retired, and then he will say, oh ma'am, see, board had also approved, I had not taken this decision, but now somebody has gone and filed a complaint. Tomorrow somebody will file a private complaint, investigation will start.
So you're saying that all your litigation after arbitration is only because of this reason?
See, litigation after arbitration is one reason where, from the date of the award, haven't you seen, sir would have seen people, sometimes public bodies also contest why arbitrator should be appointed. Okay. And the law is very clear, mostly arbitrator is appointed by the court now. Yes. So there is no point contesting. It's a very simple thing. Whatever issues you have, you can get it recorded that I will raise before the arbitrator. You'll save time there also. So I think if these decisions are taken, it will become faster for the PSU also.
Point very well taken. I'll go to the next round of question. ONGC chairman Arun Singh said that we are making contracts very rigid, what you addressed just now, and that is leading to unnecessary dispute. He says rigid contracts lead to disputes which takes 2 to 3 years to resolve. Uh, he says we have to work around that, but then that's them. He also said that we are losing, so for example, if they have a 40,000 crore project, they'll lose 4,000 crores if it gets delayed by 1 year. That's again for ONGC, which is a fairly large company. Secondly, he is also speaking in favor of institutional arbitration, saying a lot of foreign tie-ups that they have experience of institutional arbitration abroad. They want to do the same in India. And one thing that he's highlighted is that the foreign arbitration happens much faster as compared to arbitration in India, and this is what he's requesting, that like what happens in Singapore, and of course who would better than you know because you're a judge there, that is the model we should follow for arbitration to be sort of successful in India. What do you have to think about all of this?
Again, I think there's so many issues raised in this particular statement. First is ad hoc versus institutional arbitration, then international institutional arbitration, the way they function to meet the timelines, etc. Going by his, perception, I would say that the international arbitrations go far speedily than our domestic arbitration. So I try to reply it one by one. Yes, I am for institutional arbitrations for so many reasons. First of all, when it is institutional arbitration, and here when I say institution, not necessarily international institution or domestic institutions, where institutions in India also, there are quite a few which are really good. DIAC is doing well.
Yeah.
ICA is one of the oldest and again doing well. Then Mumbai, this is institution also, and there are many others. But I'm not going into the merits and demerits of this, but in institutional arbitration, yeah, because in ad hoc, all these institutions have their rules.
Okay.
And one is, so very first good thing is, if there is in the agreement, it is said that if any dispute arises, we will go by, if it is international, say SIAC or LCIA, ICC, or if it is domestic, say we say DIAC or ICA, etc. Then immediately the arbitrators are appointed.
Okay.
Not that they are not appointed and you move an application under section 11 which takes months together before even the arbitral tribunal is constituted. Yes. And the very purpose of speedy disputes and time essence is lost at the very first stage. Yes. But that is the first advantage. Another advantage is that they have, as I said, they have rules, procedure, etc., and rules in respect of everything. Yes. About the integrity, etc., of the arbitrators, the integrity of the process, and how it has to be taken. And most of these arbitral now these institutions, it is there in international institution, but in DIAC has also adopted. Once the award is given, the award is submitted to the this institution. They go into that, not the conclusion which are arrived at, because that's for the arbitral tribunal, but then whether all procedural fairness, etc., is taken into consideration, the way the manner in which it has proceeded, principles of natural justice, etc., are followed, or there are some errors, factual or otherwise. So they point out that, so that the awards are corrected, and therefore the chances of challenging that award in the court are minimalized. Yes. And then fee. Yes, is regulated by the institution. So these, and there are many other good reasons for this. And in ad hoc, of course, ad hoc whenever, because in India today, even today, I think 50-60% or even more cases may be ad hoc cases only, where the arbitral tribunals are prescribing the procedure with the consent of the parties. It may be creating certain problems also. In international arbitration or wherever there are rules, sometimes procedural issues do arise, which are flagged with the one party or the other party will flag. Yes. But the arbitral tribunal, referring to those particular rules, is able to answer that, and which may include about the integrity of where, because of the rule of competence. Yes. If it is challenged, biasness or due process, etc., first the arbitral tribunal itself has to decide. So, but those can be decided. So there are various advantages of institutional arbitration, and they will see this most importantly in the context of timelines. These institutional arbitrations, particularly international institutions, they follow it up also whether the arbitrators are doing with a good speed or not, or unnecessarily delaying. So if the delay is taking place, it is not because of the arbitrator or parties, etc. Even if it is parties, why the arbitrators are not trying to control that? So those things are there, because in future, whether the particular arbitrator will again be appointed or not, and the arbitrators are interested in that, they want work again. So therefore, they will behave in a much dignified and much proper manner. So institutional arbitration should be there. Now coming to this speedily and domestic versus international, here I will have some little difference with what Mr. Arun Singh has said for two reasons. Number one, when it comes to domestic arbitrations, today we have section 29A in the Indian Arbitration Act, which says that the award is to be given within 1 year. Of course, 6 months is for the pleadings, then 1 year for the completion of this. The parties can extend it by another 6 months, so it makes it 2 years. Thereafter, court. So therefore, arbitral tribunals would normally be vigilant, because at least I would not like that every time persons are coming to the court and are seeking extension, etc. And if it is in my control, I would not allow that to happen. But there are many times situations do occur for various reasons beyond your control, beyond the control of parties also. Like in one case, we appointed say one expert. Now expert took 1 year in giving the report also, and yeah, almost, because documents are to be given, all this, and after giving the report, it is to be given to the parties to file their objections, etc., or comments if they want to file that. So therefore, sometimes these are the factors. But having said so, it's still, these timelines are there as far as 20. When Mr. Arun Singh says that 5 to 6 years, maybe, I'm not too sure, he may be including the time of challenging this award and ultimately whether the courts by the courts. So at court level, because of arrears and pendency of so many cases, they may not be in a position to decide section 34 or section 37 proceedings, etc. That may be a different thing. Vis-a-vis now international arbitrations, first of all, it is not that international arbitrations are decided within 1 year. Sorry, that is a wrong perception, wrong notion. And they also take 2 to 3, sometimes 1 year, 2 years, 3 years, depending on the nature of the dispute.
Complexity.
Because, yes, complexity of the issues. There are, I have seen some cases where it has taken 2 to 3, more than 3 years also. And because particularly international arbitrations are becoming very, very complex. And the problem is, and it is both in domestic arbitrations and international arbitrations, that again, thanks to the lawyers, the pleadings would be full of verbosity. If a particular, and more in international arbitration, I am telling you. And if a petition can be filed, or statement of claim which may cover everything in 30 pages, it will be 200 pages.
That much.
That much. And equally, the evidence. When it comes to cross-examination, then again, long, lengthy, unnecessary cross-examination. But this is the problem of domestic arbitration, not of international arbitration. Now, having said so, let me say that there are various advantages of bringing the the way international arbitration proceed, that to our domestic arbitrations. And there are various advantages. In some respect, maybe domestic arbitration may be better. But if we take a holistic view, yes, some of the practices of international the way they are conducted in a more professional manner, if I may say so. And there is, but then we have to see the ecosystem. Now I tell you, in international arbitration, from very beginning, the entire timetable is set. The very first procedural order, right, the timelines of filing the pleadings, etc., up to the final arguments. And even after the arguments, closing submissions, etc., all these timelines are set, number one. Number two, they are very strictly and obediently adhered to. by the parties.
Okay.
It's only in exceptional, very, very exceptional cases that deviation is from there.
Yes.
Well, very, very exceptional and very justified reasons. Yes. Otherwise, no, the parties and the discipline is such that yes, parties adhere, advocates adhere, etc. to those timelines. And another good thing which I have seen is that during this period, then when the different timelines are set, it's not only pleadings, thereafter say discovery, interrogatories, etc. documents. The advocates are vigilant, so vigilant that at that stage only, at the time of, I tell you, at the time of preparing the case, they are ready till end.
Okay.
Which is unlike our Indian, this thing, they will, okay, today I have to file the statement of claim, I'll only see the statement of claim and up this next thing I'll see on the next stage. But that is not the case. They have already thought, both the sides, till end how they have to proceed. Even the entire, judgments which are to be referred to and given, they are also the timeline for that also. They are not allowed to introduce judgment later except with the permission of the tribunal in exceptional cases again. So they are ready till end for everything. And at the stage of interrogatories and production of documents, again they are very, very vigilant. Now therefore, and another very important feature is when the evidence starts, it may now from today till the stage of evidence, it may be 1 year, after 1.5 years. But from the date of evidence till the arguments, say suppose 8 days, 10 days, 15 days, matter finishes.
That's all?
Yes.
15 days?
When we reach that stage, 15 days is when very, very complex cases. It may be 5-6 days to 15 days, entire evidence is recorded and entire arguments are there. And why it happens? Now, as I have seen in domestic arbitrations, discovery, production of documents, etc. at that stage, that kind of vigilance which is required or the due diligence which is required is not taken. Now, matter comes for arbitration, the evidence. Now, during evidence, the person who is cross-examining that side is coming out with documents and confronting the witness. Yes. Now, under our Evidence Act, you can, even if a document is not on record, you can confront that witness if the witness is either the author or the copy was marked to him and all. So under this garb, many of I've seen these evidence and or you have given this answer, you see from record, see from this. So many times you'll say, I'll check the record and revert. I'll check the record and revert, and the case is getting adjourned. No such thing happens in international arbitration. Every document which is to be brought is already on record, already either filed at the stage of production of documents, have got filed from the other side, or in interrogatories, all that information from the record you want, it has come on record.
So you mean the arbitrator is helpless in these things?
And in India, now what happens in domestic arbitrations, so many times pleadings, these timelines are not met.
Yes.
So we can't fix schedule till end because the dates will go for a toss. Then the extensions are sought, and here Mr. Arun Singh has said, I would say public sector has to set its house in order because most of the time they are taking extensions
it's very
for filing. And when it comes to filing of the affidavits, evidence affidavits, they are not filed on time. Again, the contractor normally is the claimant, or they would not delay it. In some cases they may, but most of the time this again delays on the part of the PSUs. And when it comes to when dates are fixed, we have seen many times 2 days or 3 days before the dates are coming, or sometimes few days before request will come that because of XYZ reason, as it happens in our courts, our lawyer is not available, or so and so is not available, he has marriage in his family and all, so cancel these dates.
Okay.
Now, out of this fear that if I don't cancel and ask them to proceed, tomorrow award will be set aside on this ground itself. The cases are. So therefore, some of the international practices, but here I would say that the mindset of all the stakeholders has to change. And I start from arbitrators. First, in international arbitration, in that kind of thing, the arbitrators have fully read each and every page of the entire submissions which are filed in advance, all the cases, all the pleadings. They know at the stage that what is the case about, what are the issues, what are the contentions on which we have to ask the questions. So during then opening submissions take place after in these 5 or 7 days after opening submission within, and the lawyers also know, the witnesses, what is on record and what is not on, what information I have to elicit. So it goes very fast and not unnecessarily lengthy. There may be many times very lengthy cross-examination, but mostly it is not.
Yes.
And closing submissions, if you won't believe, in most complex cases also I say 1 day each.
1 day, that's all?
That's all. And here we do like courts. Okay, I am giving 3 dates for arguments. Claimant has not concluded. Now case will come. Today, if it is July, now it will be in September. In September, now it will come in December. So therefore, for all these things, yes, it is needed. So first, arbitrators have to be read. Then lawyers. Again, where I have said, they have to be prepared like this, and it has to be in a professional way. And many are here good lawyers also who are in courts as well.
Yes.
They will say, okay, keep it after 4 o'clock. I'm busy in the court till
So that
4
also
o'clock.
delays the process.
That also delays the process. You are having from 4:30 to 6:30 every day only for 2 hours, and not for 5 or 6 hours every day. So these are various reasons because of which.
But thank you for sharing all this in detail, because Mr. Arun Singh has started a discussion and your contribution will only take it forward, because ADR is for all of us, for the Indian economy to flourish. We'll go to Mahesh Agarwal, Managing Partner of ALA, for his submissions on this.
See, there is no dispute that both the claimant and the respondent want expeditious disposal.
Yes.
Because claimant wants the money fast.
Yes.
And interest is running against the respondent.
Yes.
So both want it fast. Now the delay happens at every stage. First is appointment of arbitrator.
Yes.
Now you have a clause, you have to appoint an arbitrator. But for some reason or the other, mostly PSUs object or delay.
Okay.
Because of which you have to go to section 11. We have seen section 11 going to Supreme Court from 2 to 3 to 5 to 7 judges. It has taken 10 years for appointment of arbitrators.
10 years?
Yes, so many cases. So therefore the first stage is appointment of arbitral tribunal. Once that happens, then the arbitration starts. I am with Justice Sikri that nowadays, at least with this current scenario, the actual arbitration is not taking much time.
Okay.
It is actually getting over in 18 months to 24 months. Parties are cooperating. The only problem, if at all, is because of advocates, because we don't have a strong arbitration bar.
Okay.
People are going to court, want to do arbitrations also, so they require 4 to 6, Saturday, Sunday. Most delays are happening because we do not have dedicated lawyers doing arbitration Monday to Friday. If that is sorted out, I think the delay will eliminate. But the biggest problem, why, if some client comes to me and I have to choose between India jurisdiction and Singapore jurisdiction, is I will choose Singapore because after the award, there is no delay in the court.
Okay.
That's the real delay which happens. So we have first the stage of arbitral appointment, let's say 6 months to 1 year. The award maximum 18 months to 2 years, awards are kept coming. After that it's unending. In Singapore, in 6 months to 1 year, you'll go right up to the Supreme Court. Here you will, it's like a section 34. Unlike Delhi, most courts you have to go to the district court. So an award of 3 retired judges of Supreme Court is challenged before a district judge.
That is a tragedy.
Then, it's a tragedy. And then High Court and then Supreme Court. 10 years. That is the biggest problem. Now, for that there is no answer. Everybody is trying, but there is no solution.
That's a fair point you raise. I'll go to Ma'am Ruby Singh Ahuja from Karanjawala and Company for her intervention.
So I agree with Mahesh that I think now Sir has also told you what are the issues, but problem is not in arbitration. Problem is post the award. That is why people are reluctant to go in for
Problem
arbitration.
is post the award. Arbitration
I agree. Because you see what happens that everybody says that after the award, if I have to litigate for 10 years, then I rather go for a suit. That is my, because so arbitrations are expensive. There may not be court fee, but arbitration, including, the fees of the learned arbitrators, the other expenses are there. So sometimes people say, I rather file a suit than rather in going for an arbitration. Because post-award India there is an issue. There is 34 execution, and now think about it that 3 arbitrators have given an award and you are going to a district judge who, with great respect to him, it's not that he doesn't want to do it. I mean, he's a very hardworking person, but he hasn't seen that sort of subject matter
You're
before
right, I
him.
agree with
So
you.
he's also getting his education, which is, I mean, it's all very well, we have to educate people, but it becomes very expensive for the litigant, both sides. Yes. That's a problem. But having said all this, I don't think so, the government circular which has come, I want to say this, mediation can be an preferred mode, but you can't oust arbitration for any economy.
Okay.
If you're going to oust arbitration, I'm sorry, you're sending a very wrong signal to the world
investors.
that we can't set our house in order. So it's better that we are going to oust arbitration. If you want to do business with us, if you want to invest in our country, we are only going to do either litigation or mediation, which still, mediation is still very informal process.
Yes.
It is not very formal process. So I think that it's all very well. We know our flaws with the arbitration, but we need to, fix them.
One follow-up answer, ma'am, I want from you. You are almost sounding as if arbitration has just become one step to litigation. That litigation is certain. Arbitration is a pre-step.
I have seen that. I right now have a case where the award was of 350 CR and my client still has only got 40.
Okay.
So, I mean, it is happening. I'm not saying courts are to be, I think everybody has to say that we have to respect, and the learned courts also should interfere as far less possible. We are amending our Arbitration Act so many times for this reason only, because there is too much interference. If that interference goes, the awards will be dealt with sanctity.
See, I would say there may not be ultimate much interference. Maybe if 100 cases awards are challenged, court may interfere in 2 or 3 cases, not much if we go by the statistics. Perception is there because in some of the cases where the interference has come,
yes,
they have raised eyebrows.
Correct.
There may be.
Correct.
But it is primarily the delay which takes place even in deciding those
That's
cases.
the problem, sir. That is 34 will
delaying
take,
34.
Yes.
delay will take 3
Correct,
years,
correct.
5 years, then it will go to the Supreme
Ultimately,
Court.
award may be upheld.
Exactly.
But
Yes. So
process
that
is there.
decision either way has to come sooner.
So what is happening under Section 34? The Parliament is doing its best to narrow down the challenges, and the courts are doing their best to expand the scope of challenge.
One amendment must come that even in courts, in states where there is no regional jurisdiction, 34 should directly come to the High Court.
Okay.
That according to me, if you do this little, it's a very basic amendment. You don't need, lot
This
of
has to be done
discussion.
ASAP.
Should be done. Why not? I mean, if a commercial suit has to come to why not to High Court and Supreme Court? At least you're cleaning away one level, because 3 judges, 3 retired, mostly arbitration in India are by the retired judges,
Yes.
right? So 3 retired judges have already seen the case, have spent 1 or 2 years on it, given a well-reasoned award. You may have problems with it, but then it could be decided by the High Court and Supreme Court.
Point very well taken. We'll go to our last round of questions. Sir, 2 things I want to ask you. On this very front about what Ruby raised, that problems are post-award. Do you think, you've been in the Supreme Court, there should be special benches large in number so that at least this is fast-tracked, only because to create jobs, to create investment, people should not fear that in India if there is a dispute, then years are wasted. So why should we put money in this country? Because God forbid if there is a dispute, my whole project is a washout. Do you think the court sort of can work around this and create special benches?
Actually, answer is yes.
Yes.
But it is not
feasible.
A solution which can be readily found. Actually, it's not very easy for the courts to do that. Answer is yes, because of the reasons which you have yourself indicated. Number 1, as Mahesh said initially, if there is an option of going to some institution in Delhi or India, or other option is going to SIAC Singapore, I'll choose Singapore, not because award will not be given in time, or the arbitrators here are lacking in expertise, but post award it may take some time, and which would be significant time in India, and the particularly foreign investors, they don't choose Indian institutions because of this reason only.
Okay.
He said that we have no problem, but once the award comes, it will get stuck in the court here. But if it is a Singapore seated award, Singapore court will decide in 1 or 2 years up to Supreme Court.
Yes.
So therefore, as a challenge is then for enforcement, one may have to come to India. That's a different thing altogether.
Yes.
So therefore, yes, in order to create this, or rather remove this kind of impression, or create a better environment and atmosphere, dedicated benches are required. Which should be given. And Delhi did that experience. Delhi High Court started many, many years ago. Now few other high courts have also done, and therefore they are doing well. And I tell you, I sometimes feel proud of Delhi High Court for that reason. That today as an arbitrator, when the cases are cited, most apart from Supreme Court which were there, and when it comes to high courts, most of the good judgments on various points, issues are cited Delhi High Court.
Okay.
Yes.
So it is because that we are dedicated benches, and those who are good in arbitration law, they are made to sit there.
Okay.
Which is because domain expertise again is another
important.
thing. You create a particular bench there, but then you post a particular on that roster a judge who doesn't have much, expertise in commercial laws or arbitration. It is again of no use.
Yes.
So you put the judges also who have domain, and today we have. I should give or not that, like today we have appointed one that Justice Tejas Karia,
Yes.
who has been the
Yes.
a person who was totally dedicated to arbitration.
Yes.
So such a person, if he sits on arbitration as judge, and on that he'll his
Performance
efficiencies would be much more than any other person. So therefore that is needed. But where problem comes? Problem is, and in many other high courts, and this is thinking of some of the chief justices in the high courts and senior judges also, and this is thinking sometime in public and sometime advocates as well, why arbitration should be given primacy.
Okay.
There are many other cases which are also lingering on, because delays are problem in India.
Yes.
So what about that person who is behind prison?
Okay.
And he is suffering, and why
That's
you
a
should
dilemma.
not hear this appeal?
That's
Yes.
a dilemma.
And why not those which are social causes?
Yes.
And why not a case of a dismissed workman who is out of job today?
Okay.
So why these cases are given? If we want to see it from the prism of, yes, Indian economy
Society.
has to grow,
Yes.
and no, from commercial sense,
From
from
jobs.
India rather, jobs and Indian, because such an ecosystem is required even for the growth of economy.
Yes.
Why we should not have this? Because
Yes.
it attracts foreign investment also.
Yes.
So therefore, from that angle, if you see, and it should be given preference, and these should be decided, I would say yes.
Yeah.
But then such problems are to be taken care of.
Taken care of.
Again, and therefore, again we come back to sufficient number of judges,
Yes.
late appointments, etc. Although which we
But
have
I
not.
think I would appreciate.
But otherwise, yes, I agree. There should be special benches of the persons who have expertise.
Yes.
Those, presided over by those judges, so that these cases are, and it's high time now we have to dispel this notion that Indian judicial system, when it comes to arbitration or enforcement, that we are slack.
In fact, good you said it, because one of the last statements of Mr. Arun Singh is our orders, which is the arbitral awards, are very well written, many times much better than Singapore awards also. So he said that he's happy with the quality of awards, which is a great acknowledgement of the arbitration process here. Final comment from...
2 points I will make, very small. Number one, because of the confidentiality surrounding the arbitration,
Yes.
today the awards are not published.
Yes.
Correct? Until and unless there is actually 34, 37, and that also there are no arbitration law reporters which are publishing arbitration awards. I think if there is a system followed for publication of awards, that will also cut down a lot of litigation.
Okay.
Because if a PSU has gone through an arbitration right up to Supreme Court, faced an issue or the private party,
Yes.
and another dispute happens later on,
Okay.
either with the same authority or somewhere else, you have some kind of a precedent
Yes.
or a likelihood of what is going to happen.
That should be there.
Today that is completely missing. Nobody knows what's going to happen. So if there is a system of publication of awards, that will reduce time in adjudication and also help in mediation.
Very fair point.
Second point is that we can't help it in the sense that we cannot have a system that 34, 37 is decided in 1 year or 2 years. But what we can do is that after the award, at least the interim enforcement should be faster.
Okay.
So if a person has made a claim and he's got, like she said, 350 crores, there should be a deposit of 350 crores immediately.
In an escrow?
Instead of that, in an escrow or in the court, and you can withdraw subject to guarantee. If that happens, at least the person who's filed a claim gets some relief rather than waiting for 5 years.
Fair point.
So for that, if there are strict provisions of enforcement pending challenge, that will also solve a lot of problems.
Point very well taken. Ma'am Ruby Singh Ahuja, your comment.
See, as I said that I have issues with the post award. If you take small steps have domain experts in your high courts. Direct challenge should be in the high court. I mean, for example, I have a personal problem with this roster system. You know, after every 6 months, the roster changes.
Yeah,
now
you have to be heard afresh.
Then you hear afresh. If you have, and why not domain experts for every law? I mean, you can have for criminal law. I have in Supreme Court also, your list is 3 tax matters, 4th tax matter, 5th arbitration matter, 6th patent matter. So for learned judge also. After all, they are also human beings.
Yes.
You're also making them go from one
Yes.
corner to another. Have domain experts, have stability. They should be given some time, 1 year, 1.5 years to, give judgments on that subject. So it becomes easier. We have given this example earlier in your show that Justice Sikri headed the tax bench and
Yes.
see what a disposal superb it was. Nobody had a problem. Nobody was saying
Yes.
anything. So these are very easy things you can do. You can have interim orders for payment of money, and I will go 2 steps further, that amend the act if in 34 and all people are taking unnecessary adjournment, there should be special cost, because these are commercial issues.
Yes.
It's all about money. 90% it's about money. Arbitration is about
About money.
money. What
Yes.
else it is?
Yes.
So then have, you will impose cost if you take unnecessary adjournment
Yes.
post-award. People try to linger on, ki chalo, I don't have to pay the money.
Yes.
So if little bit steps are taken, Arbitration Act is being amended. And I think these procedural steps, and I think government also has to have on its, whoever is they are advising, the people who are into the field doing this, who know how adjournments are taken. So those loops, if you can close, I think it'll be
Thank
great.
you for that point. Hope that will be considered. We are going to end the show on this note with one last 1 minute comment by Justice Sikri. What do you feel of what Justice Arun Kumar Singh has done in his endeavor with his speech?
Mr. Arun Kumar Singh.
Yes.
Mr.
No, I tell you, in 1 minute I say, he has raised very valid points,
Yeah.
which are very, very necessary for reforming the arbitration ecosystem in India.
Yes.
And yes, these are to be then taken care of by all the stakeholders,
Yes.
including PSUs.
Yes.
As he is himself chairperson of
ONGC.
ONGC and Navratna
Yes.
company and one of the flagship company, and therefore he can take a lead
Yes.
to tell the public sector's CEOs can come together and decide on this. And only another comment I would make is, when he's talking about this, and of course he has given thrust to mediation also, which is necessary.
Yes.
But what Ruby has said is also to be considered by these PSUs and even the government, that yes, we should encourage mediation. I am all for mediation. First step should be mediation.
Yes.
But then you can't totally give away as far as arbitration is
You
concerned.
cannot.
Mediation failing, it should be arbitration and not the court, which will have much more serious repercussions than the arbitral system. There are arbitral, of course, it is suffering from some shortcomings, etc. And there are many things which are to be set right. But those should be set right. House should be set right. And it's, as I said earlier, also all stakeholders, including arbitrators, have to consider all these and their own shortcomings and try to improve. But that doesn't mean that, and it is impossible today, in no other country it is even can be thought of that arbitration would be dispensed with.
In fact, that's on my last note. The world's 4th largest economy has no arbitration. That is a tragedy. And we got to hear recently that 2 petroleum companies or exploration companies were considering investments in India, put on hold because India has no ADR. That was shocking for them and shocking for us also, that we may lose billions of dollars, jobs, investments, economy, work for lawyers, everything because of no arbitration. But on this note, I'd like to thank Justice Sikri, Advocate Mahesh Agarwal, Managing Partner of Agarwal Law Associates, Ma'am Ruby Singh Ahuja, Senior Partner of Karanjawala and Company. Appreciate you joining on such an engaging discussion. And to Mr. Arun Kumar Singh for thought of giving a thought-provoking speech which led to this discussion. I hope more discussions happen and arbitration is opened up because it is in India's interest. Thank you so much for joining us. Thank you.
For more such videos, subscribe to the Newsx YouTube channel, hit the bell icon.